everyone, welcome back to Hands-Free Studying for the MBE, brought to you by Brainscape. These upcoming questions are related to the civil procedure topic, discovery. Let's get started. Question 1. What is discovery, and what are the two main categories? Discovery is the process for parties to obtain information from each other and third parties. The two main categories are mandatory disclosures and requests for information. Question 2. What are the three mandatory disclosures and the deadline for each? The three mandatory disclosures are 1. Initial disclosures, 2. Expert testimony, and 3. Pretrial disclosures. Unless otherwise ordered by the court, the deadline for initial disclosures is 14 days after the discovery conference. The deadline for expert testimony is 90 days before trial. And lastly, the deadline for pretrial disclosures is 30 days before trial. Question 3. What are the 6 methods of discovery? 1. Mandatory disclosures. 2. Interrogatories. 3. Requests for admissions. 4. Requests for documents and tangible items. 5. Requests for mental or physical examinations. And 6. Depositions. Question 4. What type of information is discoverable? Unless otherwise limited by the court, discoverable information is any information that is 1. Relevant to the case, 2. Proportional to the needs of the case, and 3. Not privileged. And this is from Rule 26B1. Question 5. What type of information is not discoverable? Any information that is either irrelevant, privileged, or work product, unless there's a showing of substantial need or undue hardship. And this is found in Rule 26B1. Question 6. When is information considered relevant for discovery purposes? Information is relevant if it is more likely to make any fact in the dispute more or less likely to be true, regardless of whether it is admissible. Question 7. What is a Rule 26F conference? A Rule 26F conference initiates the discovery process. It requires that parties meet as soon as practicable to 1. Discuss the claims and defenses, and 2. Discuss the possibility for settlement. If no settlement is reached, then the parties must develop a discovery plan and submit that to the court within 14 days. And this is from Rule 26F. Question 8. What is the deadline to hold a Rule 26F conference? At least 21 days before the scheduling conference is held, and this is Rule 16B. Question number 9. Within 14 days of the Rule 26F conference, what initial disclosures do parties need to make? Parties need to disclose 1. Any contact information for individuals who are likely to have discoverable information. 2. Documents that support a party's claims or defenses. 3. Damages calculations and any material upon which this calculation is based. And 4. Insurance agreements that could satisfy all or part of a possible judgment. And this is from Rule 26F2. Question 10. What is a Rule 16B conference? And by when must this conference occur? A Rule 16B conference is a conference where the judge issues a scheduling order that details the deadlines for disclosures, filings, and other discovery issues. And this is from Rule 16A. The deadline for a Rule 16 conference is as soon as is practicable, but this must be within 90 days of the defendant being served or within 60 days of when the defendant appears, whichever is earlier. And this is from Rule 16b-2. And that's the end of your 10 flashcard study round. To reach full mastery, remember to study in Brainscape. Our mobile and web app uses the latest in spaced repetition techniques, allowing you to optimize your study time and track your progress down to the finest detail. But of course, when you're driving, cooking, exercising, or otherwise unable to navigate the app, be sure to keep listening to the rest of this hands-free studying playlist. No matter what subject you're learning and what method you're studying it, Brainscape helps you rise to your challenge.